Redistricting and drawing new majority districts for the state of Mississippi. It has now been given back to the state, and on July the 24th, the state will again be asked to present a plan, as well as any other group that would like to submit a plan to the court. The entire issue of redistricting has confused the voters of the state, not to mention many of the candidates planning to run for election or re-election this fall. And to help us understand what is happening, we welcome Representative Ed Blackmon of Canton, a backer of an alternative plan, as well as Lisa Walker with the State Democratic Party, speaking on behalf of candidates. And due to the court's ruling late yesterday afternoon, those representing the state-adopted plan will not be able to be here with us. They have gone into a meeting to revise their plan at this very hour. I thank you both for being with us this morning. I'm going to start by asking you, Representative Blackmon, just to explain to people on a very basic level, if you would please, what the redistricting process is about, what it hopes to accomplish, and why it has taken so long to do so.
Well, as you know, every 10 years a census count is done. The populations around the country are recounted. And if the districts, the electoral districts, are out of line with a norm, that is, each district has to have a equal population or as near to equal as possible, and that's called a norm, you have to reapportion or redistrict those areas. In Mississippi this year, we had a census recount, and our districts were out of line in the legislature. So we had to redraw lines in order to meet the one person, one vote criteria. And we started that process actively in January in the House of Representatives and in the Senate. What happened is that some of the factions involved were not able to agree on a consensus as to the districts, and what you had is two opposing sides emerging in the House and in the Senate. As a result of that, a plan was passed by a majority vote in each House. Those plans were submitted to the Justice Department, who under Section 5 of the Voting Rights Act are supposed to review those plans and determine whether or not they comply with the Act. In this case, both plans were rejected by the Justice Department. A lawsuit was filed by a number of people now, it seems. Initially, the lawsuit was filed by a group of black citizens. Now you have joined in that lawsuit representatives from the Senate and from the House. And I understand there are going to be some other people getting involved. So you're going to have a conglomerate of interests involved in the lawsuit that's now pending in district court. And the court, as you know, on yesterday issued an order setting out a timetable by which each of the parties were supposed to act. I think ultimately leading up to a hearing on the 29th of this month, where the court will review plans which will be submitted by any of the parties that are involved and determine which plan, if any, should be adopted by the court.
All right, let's talk, if we can, about the major differences between the plan that was voted on and taken to the Justice Department, which I believe included 38 majority districts. 29 of those VAP, or what we call voting age population, which means there is a potential that they are able to vote in a minority candidate. Is that correct?
Well, the crucial points that you're making here now is that the plan had 29 black majority districts with a black voting age population of 60% or better.
Right.
All right. What happened is that the Justice Department reviewed that plan and determined a couple of things. One, that the plan was adopted for racially impermissible purposes, and that the plan actually did not measure up to the standards outlined in Section 5 of the Voting Rights Act.
How did it not measure up, and what does your alternative plan include that this plan does not?
The letter was quite lengthy, but giving you some of the major points. It determined that many districts were fractured. There were some districts that could have been created, black districts that is, that could have been created that were not created, that they intentionally went into, for instance, the Delta area and did not create effective black majority districts. That is, that on paper, the districts appeared to be black majority, but when you looked deeper, you found that those districts were in fact formed or drafted in such a manner that it would deny blacks an equal opportunity to elect a person of their choice. For instance, they pointed out that there, in institutions such as Parchman in Sunflower County, that's District 31, Parchman has 6,500 people there who were counted in the census. They are mostly black. You put that precinct into District 31 and claim that it's a 60% black majority, when in fact it's not. Those people cannot vote. They're in prison, but they are counted as part of the population. The state submitted that district as one of the districts they would claim as one of their 29 black majority districts. And I can give you an example. For instance, Mississippi Valley State in the Delta, in LaFleur County, which I believe is District 50 or 51, has 2,800 students. Those students live all over the state, but for census purpose, they are counted in that particular area of the state. They don't vote in LaFleur County.
Did the same things not happen with, for instance, Ole Miss or Mississippi State School?
It did, and those was the same problems existed over the state, and you have to really compensate for that. In our plan, we took those things into consideration, that being the alternative plan, and we dealt with those situations where we found them, and therefore our plan is the more effective plan because we take into consideration that you have institutions there, that also in other areas you had what we call districts or precincts in which have been affected from a historical standpoint by racial oppression, economic depression, illiteracy. All those things have to go into consideration when you determine whether or not you're creating effective districts. The state plan which was adopted ignored that, in fact, went looking for those kinds of districts to put into black majority districts in order to claim that they were black majority districts.
Unfortunately, they are not here to defend themselves this morning, but let me ask you, do you think the alternative plan would have passed with the Justice Department?
I'm positive it would have.
All right, may I give you a quote from Justice Dunn, the Assistant Attorney General under Thornburg, who told Governor Mabus and Attorney General Moore that said the alternative plan as presented to them would have failed.
Well, I'm glad you asked that question. That question has been used and misused, that statement. That is not a fact. In fact, the date that that quote first came out, the Justice Department officials were so disturbed by it that they stayed in their office to 7:30 that night and said, you have the governor and the Attorney General call us so we can clarify that for them. And in fact, later on they gave me a number of their public affairs person who anybody who doubted that could call, and they would tell them that, one, the Justice Department would never give an advisory opinion on any plan that was not before it. And the only plan that they consider is a legislatively passed plan. So they would never tell anybody as to what they would or would not do with some plan that's not legislatively passed.
And unfortunately, Justice Dunn is not with us this morning, so he cannot speak for himself.
Well, you have my answer, which I assure you is the correct answer.
Okay. We are going to take a quick break. Lisa, I want to come back and talk with you about what this is doing to candidates who want to run for office, and we will be taking your calls, so please hang on, callers.
I think the hardest thing about being in an emergency room.
And we are continuing our discussion this morning on redistricting with Representative Ed Blackmon of Canton and Lisa Walker with the State Democratic Party. And Lisa, I want to talk to you for a moment about what this does. Not knowing what your district is, how does it affect the candidates? Now the courts have said or left open-ended the date for filing. It was to be this Friday, but if you don't know what your district is, how do you know whether or not you want to file to be reelected, whether there's an incumbent in your district, whether there'll be two of you in one district?
That's right. This has become a very, very confusing issue. We take probably 10 calls a day from people who say, I've looked at this race for 4 years and been very interested in running, and now I don't even know if I'm in the district where I've grown up. And so there's a whole lot of confusion about it, and unfortunately every day people are pushed by rumors. Yesterday I went to listen to the three-judge court to hear what they would rule on the qualifying deadline, because I thought at least we'd have that much clarification yesterday.
No such luck.
Yeah, instead of hearing a particular date, now it's set, open-ended.
However, the primaries are still set for September the 19th, which means now the amount of time to get to know the candidate who will be running in your district for us as a voter is getting smaller and smaller, correct?
I think the only thing that there happens to be consensus on among all the groups that are divided over this issue is that everyone wants the elections to go on time and as scheduled. But what that does is we're possibly facing then a 30-day election for some people. It's quite possible that the deadline for qualifying may be as late as August 16th, which means in 30 days the Republican Party and the Democratic Party have to provide ballots to everyone in the state in that time, and people who run voting machines have to send out of state to get that done. So there's a tight squeeze there, but also if you're a candidate, you have only 30 days to get your name out.
And that is a big problem. Does this favor the incumbent, since their name is already out?
It certainly does. The incumbent has been around for at least 4 years and is known within the area, so
and it's also,
name recognition plays a major role in elections.
It's also possible now that there be two incumbents in one district.
It certainly is.
So then you've got a whole new race that you're looking at, an entirely different game that you need to play.
Well, I think that this is going to be a very different race for the legislature this year because of that, meaning that you're going to have a lot of people scrambling for one they're going to be incumbents who are going to find themselves in entirely new districts, and then you're going to find incumbents with each other. You're going to find perhaps incumbents having to do a lot of maneuvering just so they can change what they plan to do. They're going to raise money for one type of race, find that they have a different. So it's going to be a lot of different things are going to be happening.
All right, I am going to go to the phone lines because there are lots of callers who would like to give us their opinions or their comments. And good morning, caller. What would you like to say?
Good morning. First of all, I would like to begin with...
Caller, you need to speak up. We can't hear you.
Oh, excuse me. First of all, I would like to begin with a question. And my question is, why is the legislature having so many problems coming up with a plan on redistricting that's acceptable to the Justice Department? And my feeling about the matter is that here in Mississippi, you have a group trying to prevent another group from having equal representation in the political arena.
Can you all hear them?
I believe I made out her question was why was the legislature having so much difficulty
am I speaking too long?
coming up with a plan. And my response is that what happened this year, they were involved in what they've called a speaker's race within the reapportionment process. That automatically puts people on different sides of the fence. Then you factor in the racial issue, which means that the state was obligated under the Voting Rights Act, one, to not dilute black voting strength, and two, to create as many black majority districts as possible. So that was in the middle, kind of squeezed, and with the competing interest there, with the Speaker Tim's Ford group really being in charge of the initial drafting process, then it created a very difficult job for the legislature to overcome.
In other words, are you saying it's become a very political issue? I mean, that there are factions who not only their interest has maybe wavered even from the original purpose of just trying to come up with good majority districts?
Well, ordinarily, in the purest of senses, you're going to have politics involved in redrawing districts. But when you throw in those two factors I just mentioned, it makes it even more difficult.
All right. And I believe we have another caller on the line. Caller, go ahead with your comment, if you would, please.
Yes, I'm in Covington County, and I would like to know why as the Negro race being put out of town.
Caller, can you speak up a little louder, please?
I'm calling from Covington County.
Uh-huh.
And I would like to know why the Negroes are being put in out of District 3. We have voted in District 3 for a number of years, but now we are being transferred, and I don't understand why.
Do you feel qualified to answer that, Representative Blackmon?
What county did she say she was from?
District 3.
She's talking about a supervisory. That does not sound like a supervisory district. She may be talking about she may be talking about county supervisory districts. That's what it sounds like she's saying. Now, of course, I'm not qualified to talk about Covington County's politics.
She wants to know why voters are being moved out of District 3.
She's talking about supervisory districts.
Okay.
And it's good we don't have to redraw supervisory districts.
But it does raise a very good point. There are even voters now who aren't sure what precinct they're going to be voting in.
Sure.
And it leaves a lot of people feeling unsettled.
Let me ask you also, is this process going to start removing legislators from the neighborhoods that they know from their constituents and moving them into areas where they haven't been living and aren't as familiar with their constituents?
Yes. Unfortunately, that will happen in some instances because the two things that you must adhere to is one person, one vote, and Section 5 of the Voting Rights Act. And because of that, there will have to be some major changes made in present districts.
All right. We would like to take one more call if we could. And good morning, caller. Go ahead with your comment. I believe we've lost that caller. I apologize. From here, you see what's happening, Representative Blackmon.
Well, on the 24th, all parties involved in the lawsuit will have to submit their proposed plans to the court. On the 26th of this month, the Justice Department, who has been asked to come in as a friend of the court, can look over those proposed districts and make a recommendation as to which is the preferable district under the Voting Rights Act. The court then will convene and have a hearing on the 29th and will decide, I believe, on that date which plan it intends to adopt. After that, though, that plan will have to again be submitted to the Justice Department for pre-clearance under Section 5.
All right, and Lisa, your advice to voters would be try to pay attention as best as you can and find out who's going to be running before the 19th?
Well, exactly.
All right, thank you both for being with us this morning. We appreciate it.
right,
Good
thank
luck.
you.
I know there are a lot of voters watching. We'll be right back.
And the Senate, and after an hour, announced no special session.
Real seriously. We got on the phone last night, this morning. We had this meeting. We talked to a lot of legislators from a lot of different viewpoints. And the only consensus they came up with was there was no consensus.
Attorney General Mike Moore says that means the state is in for a costly court-drawn redistricting plan. Moore says already more has been spent on the court plan than would have been spent during a special session.
Secretary of State Dick Malpass today predicted that elections for state House and Senate seats will not be delayed by the redistricting fight, but Malpass says a solution to the
The governor met with lawmakers on all sides of the redistricting dispute in a closed-door meeting for almost 2 hours this evening. The governor says the worst thing he could do is call a special session for redistricting, only to have lawmakers end in gridlock.
A lot of phone calls in this meeting today, it became real clear that there's only one decision that really could be made, and that is that no special session would be productive right now. Because the court yesterday made the suggestion, well, look at a special session. We took that real seriously.
Mavis also says he will continue to work with lawmakers to reach some kind of out-of-court settlement.
This afternoon to see if any agreement could be reached if a special session was called. But the governor says at this point a special session would not appear to produce a settlement.
I think the worst thing would be to call them in and have them gridlock, have them dissolve into the divisions that they had before.
Meanwhile, Secretary of State Dick Malpass says that a federal court order delaying the qualifying date for legislative elections applies only to legislative races. Candidates for all other offices still have to qualify by this Friday.
Hinds County School Board officials want county residents to take on negotiations over the plan to remap the legislative districts broke down this afternoon.
The parties involved in the lawsuit met in a short, closed-door meeting. During that meeting, negotiations broke down between House members.
What's the status of the negotiation?
I'm going to my car.
What's the status? They said that you walked out on the meeting.
Is that what happened?
Tell us.
No, I didn't walk out. I did leave the room, but it wasn't a walkout.
I'm trying to negotiate to the end in good faith. I'm trying to comply with the law. That's all I can do. The law said that we're entitled to the maximum black district, and that's what we want. And that's it.
House members who support the plan passed during the session say their revised plan creates the maximum black districts, and the fight now boils down to politics.
It's over who's in which district and who's not in one district and how much of their county they've got and whether their opponents carved out of the other county, and that's stuff that we agreed not to even discuss about it, and that all we were supposed to do was to settle the Section 5 problems, to create the number of districts under the Voting Rights Act, and we've done that.
The chairwoman of the House Committee on Redistricting agreed the battle now is over which representatives will be protected under the new districts.
I think that has been at the core of the entire process. Sad to say, but I think that there's general agreement that we need to create majority black districts wherever possible. But now there is contention that goes back to the leadership fight in the House.
Meanwhile, senators were not taking part in any negotiations. It appears the Senate plan will be drawn by the three-judge panel named to handle redistricting. That panel was appointed earlier this month after the state's redistricting plan was rejected by the U.S. Department of Justice. Warren Strain, WLBT News.
That three-judge panel will meet in the morning at 10:15 to begin the process of coming up with a redistricting plan. Closing arguments are set to begin Monday in the
Night or 10 o'clock in the morning that we will have a settlement.
The Justice Department earlier rejected the legislature's plan, citing not enough majority black districts. If no settlement is reached, voting lines will be drawn by the courts.
Garrett out of court. Representatives and senators have until 10:15 tomorrow morning to hash out their differences, or the case will go to court. 9 black Mississippians in a June lawsuit claim that proposed House and Senate districts are racially discriminating. House members say they're very close to reaching a settlement.
With the maximum black district, what we cannot agree on at this time is the other district, and I think that's where politics and loyalty and other factions enter into play. And if we can resolve that, I think we'll have a settlement.
However, an out-of-court settlement over the Senate's redistricting plan appears unlikely at this hour. The Mississippi Forestry Commission...
Do something.
The federal court today said it may order this year's elections to go forward under current district lines, even though all sides agree the current districts are unconstitutional.
To run under the 1982 plan, you'd have malapportionment problems. But as the court said this morning, there are exigent circumstances, basically that the people of Mississippi need to vote.